After filing my petition, serving my papers, and waiting for my hearing date, I thought the hard part was over. I thought we would finally talk about the evidence, the medical records, the trust, the circumstances surrounding our disinheritance. I was wrong. What surprised me most about my first hearing was how little we discussed the facts of the case. Instead, the court focused almost entirely on procedure. If you're preparing for your first probate hearing, here's what I wish someone had explained to me. Now, my experience comes from Los Angeles Superior Court. Procedures may vary between counties, courthouses, and judges, but this will give you a general idea of what to expect. Before your hearing date arrives, you'll receive a case number and a court date and time. In my case, the hearing was typically scheduled for 8:30 in the morning. What I didn't realize was that dozens of other people had been given that same time slot. You're not the only one on the calendar. You're one of many. That means you may spend more time waiting than actually speaking. You do have the option of attending in person or remotely. I've attended both hearings, both in person and remotely. These days, I usually appear online because it's convenient and saves time. But if you're not comfortable with technology, I would seriously consider attending in person. When all six of us have appeared remotely, at least one of us has had technical difficulty at every hearing. They either couldn't log in, they couldn't hear, they didn't know how to turn their microphone on, they didn't know how to mute themselves. If technology makes you nervous, attending in person may be one less thing to worry about on an already stressful day. If you're attending remotely, the clerk will usually take roll call around 8:30 before the judge enters the courtroom. The purpose is simple. The court wants to know who's present. If you're attending in person, you'll typically check in with the courtroom bailiff. In my courtroom, we filled out a form identifying ourselves and our case before entering the court. A few minutes before the judge takes the bench, everyone is brought into the courtroom. Right before the hearing begins, you may be asked to stand, raise your right hand, and take an oath to tell the truth. At that point, the courtroom is ready to begin the day's calendar. Before my first hearing, I attended a free workshop held monthly through the LA Law Library. During the Q&A, I asked the probate attorney, "What should I expect at my first court hearing?" Her answer surprised me. She said, "Nothing. You'll get another court date." At the time, I thought she was joking. After all, I'd spent weeks preparing, rereading documents, making extra copies. I wanted to be ready to explain everything that had happened. But she was right. When our case was called, the judge asked who was present from each side. He then turned to us and asked, "Did you read the probate notes?" I had no idea what probate notes were. I quickly wrote probate notes on my notepad and said, "No." The judge then asked if I knew how to find them. I said, "No, but I'll figure it out." He smiled and said, "Hold on, my clerk will print them out for you." He then told me I needed to respond to items A through M. I had no idea what that meant either, but I wrote it down. Then guess what? The judge set another court date, and that was my first court hearing. To be honest, my second hearing wasn't much different. I responded to most of the probate notes. A few of them weren't questions, but statements or observations. I didn't realize I needed to respond to those comments too. So the judge gave me another court date. At first, I thought probate court was where I would finally tell my entire story. Instead, I learned that the first hearing is usually about procedure. The court wants to make sure the right papers were filed, the right people were notified, and the case is ready to move forward. Looking back, the attorney was mostly right. Nothing didn't quite happen. I learned what probate notes were. I learned the things that still needed to be addressed. However, I did get another court date. Understanding that made my future court appearances much less stressful. Looking back, those first few court appearances were more about procedure and not the substance of our case. The court wasn't asking me to prove undue influence. The court wasn't asking me to prove lack of capacity. The court wasn't asking me to tell my story. Instead, The court wanted to know things like, did we have standing? Had the other side been properly notified? Was the summons issued and personally served? If the trust was invalidated, who would administer the estate? Has a petition for probate been filed? In other words, the court was focused on whether the case was procedurally ready to move forward, not whether we had already proven our claims. If you're trying to determine where you stand and whether you have a probate case, take my free quiz, Do I Have a Probate Case, in the pinned comment below. The quiz will help you think through questions about standing, deadlines, and legal grounds. You'll also receive my free evidence checklist to help you organize your facts and evidence.